Good morning, most people. I hope you get to sleep, and I will get my sleep after this stream. But I figured I'd do a new test stream on dealing with monetization and reading case laws. And I figured this would be a good case law to read up on since it was just decided summer of this year out of the Third Circuit Court. And a quick background on this case. The ACLU did a pretty good write-up here. The American Civil Liberties Union of Pennsylvania and co-counsel filed a federal lawsuit on behalf of a Temple undergraduate student who was arrested for photographing on-duty Philadelphia police officers. This is the fourth in a series of ACLU Pennsylvania lawsuits aimed at stopping Philadelphia Police Department's illegal practice of arresting citizens in retaliation for observing or recording the police performing their duties. Hello, new subscriber, Calm Mooney. Anyway, getting back to reading here. Uh, According to the lawsuit, the practice is routine despite a September 2011 memo from PPPD Commissioner Charles Ramsey reminding officers that individuals have a First Amendment right to photograph and record them. In December 2015, the city moved for a partial summary judgment, asking the court to dismiss all claims against the city and First Amendment retaliation, illegal search, and malicious prosecution claims against Officer Siska on February 19th, 2016. Hello, everyone. Judge Kearney granted summary judgment to the defendants on First Amendment claims. He ruled civilians have no First Amendment right to record police unless they are doing it for the purpose of criticizing the police. The ACLU appealed this ruling to the U.S. Court of Appeals for the Third Circuit. And right there is the reason why this is actually such a big case, was because the district court judge gave a really weird off-the-wall ruling, stating essentially that people have to either be in the act of using their freedom of speech criticizing the officer or talking with the officer in order to be able to allow to record them, or something along those lines. And so after all that, we'll go ahead and that's the basic brief run up to the actual case here. And of course, we're going to sit back and read more about this case here. This decision came through, where is it? Usually the date, here it is. It was argued on May 9th, 2017, and the opinion came out in July 7th, 2017. Just about, I think about 3 months after the Turner v. Driver case, which I do plan on eventually reading on this channel here. And here's a list of lawyers that were involved and all that stuff. But let's get down to the nitty-gritty. Opinion of the court. Ambrose Circuit Judge. In 1991, George Holliday recorded a video of a Los Angeles Police Department officer beating Rodney King and submitted it to the local news. Filming police on the job was rare then, but common now. Hold on, I got a burp. I've been drinking soda here. Damn it. Oh well. I'll burp it up here in a minute. Filming police on the job was rare. Oh, it's common now. With advances in technology, can you increase your audio settings, BB? I'll go ahead and increase it. I can only be so loud. I gotta keep quiet. Actually, my audio settings are pretty well maxed out. Let me see if I can adjust the gain a little bit here. Okay, I have adjusted it. I've increased it within OBS. Hopefully that'll be enough, but I don't want to accidentally blow out everybody's ears. Okay. Continuing on with the reading. I'm sorry if I'm too quiet, but I can only be so loud here. With advances in technology and widespread ownership of smartphones, civilian recording police officer is ubiquitous. Samson watching reference to a prior case. These recordings have both exposed police misconduct and exonerated officers from errant charges. However, despite the growing frequency of private citizens recording police activity and the importance to all involved, some jurisdictions have attempted to regulate the extent of this practice. Individuals making recordings have also faced retaliation by officers, such as arresting on false criminal charges and even violence. The case involves retaliation. Richard Fields and Amanda Gracia attempted to record Philadelphia police officers carrying out official duties in public and retaliated against, even though the Philadelphia Police Department police policies recognize that private individuals have First Amendment rights to observe and record police officers engaging in the public discharge of their duties. No party consented to the extent of the First Amendment right, yet district court concluded that neither plaintiff had engaged in First Amendment activity because the act of recording, was not sufficiently expressive. However, this case is not about whether the plaintiff expressed themselves through conduct. It is whether they have a First Amendment right of access to information about how our public servants operate in public. Every circuit court of appeals to address this issue, 1st, 5th, 7th, 9th, and 11th, has held that there is a First Amendment right to record police activity in public. See Turner v. Driver. Let's see, 5th Circuit, Garrick v. Began. Let's see, ACLU v. Alvarez. Glick v. Cunniffe, Smith v. City of Cumming, Fordyce v. City of Seattle. Today we join the growing consensus. Simply put, the First Amendment protects the act of photographing, filming, or otherwise recording police officers conducting their official duties in public. In September 2012, Amanda Garcia, a member of a police watchdog group Up Against the Law, attended an anti-fracking protest at Philadelphia Convention Center. She carried her camera and wore a pink bandana to identify her as an illegal observer. About a half hour into a protest, the police acted to arrest a protester. Garcia moved to a better vantage point to record the arrest and did so without interfering with the police. An officer abruptly pushed Garcia and pinning her against a pillar for 1 to 3 minutes, which prevented her from observing or recording the arrest. Garcia was not arrested or cited. Quite interesting right there. Let's see here. One evening in September 2013, Richard Fields, a sophomore at Temple University, was on a public sidewalk where he observed a number of police officers breaking up a house party across the street. The nearest officer was 15 feet away from him. Using his iPhone, he took a photograph of the scene. An officer noticed Fields taking the photo and asked him whether he liked taking pictures of grown men and ordered him to leave. Fields refused, so the officer arrested him, confiscated his phone, and detained him. The officer searched Fields' phone and opened several videos and other photos. Officers then released Fields and issued him a citation for obstructing highway and other public passage. These charges were withdrawn when the officer did not appear at the court hearing. This is actually quite common. Beyond just that. Is it really that quiet? I'm talking quite loud, actually. According to my meter, it's quite loud. In fact, here, I'm actually just going to go ahead and test this. There will be an echo, obviously. And, oops. Another photo. Officer then released Fields and issued him a citation for obstructing highway and other public passage. The audio's coming over quite loudly on my side, it looks like. These charges were withdrawn? Yeah. When the officer... I'm not sure what exactly is going on for everybody else that is trying to listen in. I have amplified the hell out of my microphone. So... Anyway, let's go ahead and continue on with this reading. And as is in the link of the description Oh, in the description there is a link to this if you just want to go ahead and read this. Let's see here. Okay, no, I'm gonna get back to reading this, guys. I'm sorry if you have a problem, but I've done a lot on my end to amplify it quite a bit. So, okay. Notice, okay, withdrawn. Okay, let's continue on with the next paragraph. Fields and Garcia brought 42 U.S.C. 1983 claims against the city of Philadelphia and certain police officers. They alleged the officers illegally retaliated against them for exercising their First Amendment right to record to record public police activity and violated their Fourth Amendment right to free from unreasonable search and seizures. They also pointed out that the city police department official policies recognize the First Amendment right. In 2011, the department published a memorandum advising officers not to interfere with private citizens' recording of police activities because it was protected by the First Amendment. In 2012, it published an official directive reiterating that this right existed. Both the memorandum and directive were read to the police officers during roll call for 3 straight days. And in 2014, after the events in our case and the occurrence of a similar incident, the department instituted a formal training program to ensure officers ceased retaliating against bystanders who recorded their activities. The district court nonetheless granted summary judgment in favor of the defendants on the First Amendment claims. They did not argue against the existence of the First Amendment right, but rather contended that the individual officers were entitled to qualified immunity and the city could not be vicariously liable for the officers' acts. Yet the district court on its own decided that plaintiffs' activities were not protected by First Amendment because they presented no evidence that their conduct may be construed as an expression or a belief or criticism of police activity. Let's see. Citing the the district court case. When confronted by police, the plaintiffs did not express their reasons for recording. The later deposition testimony showed that Garcia simply wanted the observe and Fields wanted to take picture of an interesting and cool scene. In addition, neither testified of having an intent to share his or her photos or videos. The district court thus concluded, absent of any authority from the Supreme Court or the Court of Appeals, we decline to create a new First Amendment right for citizens to photograph officers when they have no expressive purpose, such as challenging police actions. Which was quite the interesting part right there. Because of this ruling, district court did not reach the issue of qualified immunity or municipal liability. However, it allowed the Fourth Amendment claims to go through trial. The citizens are not without remedy because once the police officer takes your phone, alters your technology, arrests you, or applies excessive force, we proceed to trial on Fourth Amendment claims. By stipulation, plaintiffs dismissed their Fourth Amendment claims so that they could immediately appeal the First Amendment ruling. District Court had subject matter jurisdiction over the federal civil rights claims under 28 U.S.C. 1331 and 1343, and have jurisdiction under 28 U.S.C. 1291. We exercise plenary review over District Court grant of summary judgment, citing to Morales Incorporated v. City of Pittsburgh, 2010. It is appropriate only where drawing all reasonable inferences in favor of non-moving party, there is no genuine issue to any material fact, and the moving party is entitled to judgment of matter of law. Alteration in original and citation omitted. Because of this is the First Amendment case, we must also engage in searching independent factual review of the full record. Okay, now we're going to move into the order of analysis. Need the sugar to stay awake. Defendant asked us to avoid ruling on First Amendment issues. Instead, they want us to hold that, regardless of the existence, the officers are entitled to qualified immunity, and the city cannot be vicariously liable for the officers' acts. We reject this invitation to take easy way out. Because the First Amendment issue is great importance and recording of police activity is a widespread common practice, we deal with it before addressing, if needed, defense to liability. In Saucer v. Katz, the Supreme Court held that the courts must determine whether constitutional rights existed before deciding if it had been clearly established, such that the defendant would not be entitled to qualified immunity. 533 U.S. 194. Less than a decade later, however, the court reversed course in Pearson v. Callahan, um, holding that the courts instead have discretion to choose to address immunity first and bypass the substantive constitutional issue, citing 555 U.S. 223 and 236. We have not ruled on First Amendment right, instead merely holding that at the time of our ruling, the claimed right was not clearly established, citing Kelly v. Borough of Carlslee and True Blue Auctions v. Foster. In years since, First Amendment issues from the recording of police activity reoccur, and they deal directly with the constitutional doctrine. With technological progress and the ubiquity of smartphone ownership, especially in the years since our Kelly decision, we are now in the age where the public can record public officials' conduct and easily distribute that recording widely. Okay. Oh, glad that you got the audio issues fixed. Maybe we might work something in like that. Anyway, continuing on. The increase in observation, recording, and sharing of police activity has contributed greatly to our national discussion of proper policing. Consequently, police departments nationwide, often with input from the U.S. Department of Justice, are developing policies addressing precisely these issues, in our opinion, can assist in their efforts to comply with the Constitution. Moreover, the case before us, the constitutional question, is not so fabricated that our decision will provide little guidance for future cases. All we need to decide is whether the First Amendment protects the act of recording police, officers carrying out official duties in public places. We have excellent briefing on appeal, including counsel for the parties in 8 amici, including the U.S. Department of Justice, the Cato Institute, well-known First Amendment law professor, and some of the largest news organizations in the country. We therefore address the First Amendment question before moving to the defense. And the Cato Institute and a well-known First Amendment law professor. I wonder who that is. I'm gonna have to look up who's that they're referring to there. The First Amendment right to record. This should be interesting. The district court concluded that plaintiffs engage in conduct only the act of making a recording, as opposed to expressive conduct using the recording to criticize the police or otherwise comment on officers' actions. It did so by analogy, applying the expressive actions. It did so by reading the sentence. Did so by applying by analogy, applying the expressive conduct test used to address symbolic speech. Conduct is protected by the First Amendment when the nature of the activity, combined with the factual context and the environment in which it was undertaken, shows that the activity was sufficiently imbued with the elements of communication to fall within the First Amendment scope. And they're citing the Tinflay, Incorporated v. Borough of Tinflay. What Garth is going... I have no idea. I haven't really kept up with everybody's videos. Continuing on. We disagree on various fronts. Foremost, that the district court focused on whether plaintiffs had an expressive intent such as the desire to disseminate the recordings or to use them to criticize the police. At the moment when they recorded or attempted to record the police activity, this reasoning ignores the value of the recording may not be immediately obvious, and only after review of them does the worth of their worth become apparent. The First Amendment protects actual photos, videos, and recordings. Brown v. Emmett Merchants. I'm not sure if this is a Supreme Court case, 2011. And for this protection to have meaning, the amendment must also protect the act of creating that material. I'm actually going to go ahead and do a quick search with this. Is this a Supreme Court case? Is this SCOTUS? Yeah, okay, that is a SCOTUS case. So that is case law right there, federal case law. Continue on. There is no practical difference between allowing policies to prevent people from taking recordings and actual banning the possession or distribution of them. Let's see, Alvarez. Restricting the use of audio or audiovisual recording devices suppress speech just as effectively as restricting the dissemination of the resulting recording. Cato Institute, Amicus, BR, I guess page 7. Both precedent and first principles demonstrate that the First Amendment protects the process of capturing inputs that may yield expression, not just in the final act of expression itself. Quite the interesting reference there. Kamer, another one. The threat of arrest remains a potent deterrent to spontaneous photographers who have no deep commitment to capturing any particular image. As illustrated here, because the officer stopped Miss Garcia from recording the arrest of the protester, she never had the opportunity to decide to put any recording to expressive use. And that is true. If they prevent you from being able to get the footage, how can it have a chance to be used in an expressive manner? Plaintiffs and some amici, argue that the act of recording is inherently expressive conduct, like painting, writing a diary, dancing, or marching in a parade. First Amendment law professor Amicus BR, if writing an undisturbed diary is speech, making an undisturbed recording can be characterized as speech as well. Society for Photographic Education, Amicus BR2, making a photograph merits First Amendment protection because it's an artistic expression, just the same as painting a landscape, sketching a street scene, or sculpting a statue. Ooh, these are really good arguments. I'm really liking this. Continue on. Regardless of the merits of these arguments, our case is not about the people attempting to create art with police as their subjects. It is about recording police officers performing their official duties. The First Amendment protects the public's right to access to information about their officials' public activities. It goes beyond protection of the press and the self-expression of individuals to prohibit government from limiting the stock information from which the members of the public may draw. First, and I'm going to pause here, and I want to make a comment here, because this is right here can be applied to the issues currently with the post offices, where they're saying you cannot film their employees when you're filming the inside interior area. And so we already seeing a legal argument in the federal appeals court right here, and I'm pretty sure the ACLU v. Alvarez case has similar wording too, where has the same legal arguments where we're allowed to film public officials while in the conduct of their official duties. And so we probably are going to have a point where we're going to end up tackling in the next couple of years a civil lawsuit, or a federal case against the post office on these issues and challenging their no filming policies and stuff like that. Anyway, continuing on. First National Bank of Boss v. Ballantyne, 1978. Access to information regarding public police activity is particularly important because it leads to citizen discourse on public issues. The highest rung of the hierarchy of First Amendment values and the entitled to special protection, Snyder v. Phelps. Ooh. And for those who are not familiar, this is 2011. This is the Supreme Court case that was dealing with the Westboro Baptist Church protesting at soldiers' funerals, and whether they be illegally allowed to do that or not. And they were allowed to be legally allowed to do that. That was dealing with sort of like offensive speech issues. And then they have Garrison v. Louisiana, 1964, recognizing that paramount public interest in the free flow of information to the people concerning public officials, their servants, that the information is wellspring of our debates, as the latter are to be uninhibited, robust, and wide open. Snyder, let's see, quoting the New York Times Co. v. Sullivan, the more credible information, the more credible are the debates. Which is, that I really like that sentence right there. The more credible the information, the more credible the debates are. To record what there is the right for the eye to see or the ear to hear corroborates or lays aside subjective impressions for objective facts. Hence, to record is to see and hear more accurately. Recordings also facilitate discussion because of the ease in which they can be widely distributed via different forms of media. Accordingly, recording police activities in public falls squarely within the First Amendment right of access to information. No doubt, the press has this right. So does the public. See PG Publico v. or I'm not even sure how to pronounce that. Third Circuit, 2013, and Brasenberg v. Hayes, 1972. Bystander videos provide different perspectives than police and dashboard cameras, pertaining circumstances and surroundings that the police videos often do not capture, which is very true, especially when that footage disappears. Civilian video also fills the gap created when police choose not to record or withhold their footage from the public. What I was just saying. See National Police Accountability Project, BR7, that noting that a recent survey of 50 major police departments' policies on body cameras revealed that many policies either failed to make clear when officers must turn on their body cameras, gave officers too much discretion when to record, or failed to require an explanation when officers did not record. Citation omitted. The public creation of this content also contemplates the role of the news media. Indeed, citizens gathering and disseminating newsworthy information occur with the ease that rivals that of traditional news media. 2012 U.S. DOJ letter to Baltimore Police Department, and also a reference to Glick. The proliferation of electronic devices with video recording capability means that many of our images of current events come from bystanders with a ready cell phone or digital camera rather than traditional film crew, and news stories are now just as likely to be broken by a blogger at her computer as a reporter at a major newspaper. In addition to complementing the role of the traditional press, private recordings have improved professional reporting, as video content generated by witnesses and bystanders has become a common component of news programming. The Reporters Committee for Freedom of the Press and 31 media organizations, amicus brief 11, today, the first source of information from the scene of a newsworthy event is frequently an ordinary citizen with a smartphone, and the inclusion of bystander video entrenches the stories journalists tell, routinely adding distinct first-person perspective to news coverage. Moreover, the proliferation of bystander videos has spurred action at all levels of government to address police misconduct and to protect civil rights. Another amicus brief 1 reference. These videos have helped police departments identify and discipline problem officers. They have also They have also assisted civil rights investigations and aided in police Department of Justice work with local police departments, and just the act of recording, regardless what it is recorded, may improve policing. See Gleek reference. Important to police is the recording to help them carry out their work. They, every bit, as much as we are concerned with gathering facts that support further investigation or confirmed a dead end. And of particular personal concern to police is the bystander recording can exonerate an officer charged with wrongdoing. A reference to Turner. We do not say that all recordings is protected or desirable. The right to record police is not absolute. It is subject to reasonable time, place, and manner restrictions. And they make a reference to Kelly v. Wetlands out of the Third Circuit in 1999. I'm gonna have to look that one up. That's interesting. But in public places, these restrictions are restrained. So pretty much they're making a reference. And actually, you know what? I think I did read that case when I was looking up the Eighth Circuit one. So it's basically saying that there shouldn't be any restrictions with time, place matters within a public area. We need not, however, address at length the limits of the constitutional right. Defendants offer nothing to justify their actions. Fields took a photograph across the street from where the police were breaking up a party. Garcia moved to a vantage point where she could record protesters' arrest, but did so without getting in an officer's way. If a person's recording interferes with police activity, that activity might not be protected, which I agree. For instance, recording a police conversation with confidential informant may interfere with an investigation, put life at stake, but there are no countervailing concerns. In sum, the First Amendment right of access to information, the public has the commensurate right to record, photograph, film, or audio record police officers conducting official police activity in public areas. So, pretty much right here, they're stating that we have the right to record the police in public. And though I'm a little bit iffy on their, was it the confidential informant issue? If you got a confidential informant, you're not going to be having them out in public talking with them. Morning. Yeah, soon it'll be good night for me. So, anyway, continuing on, let's finish up this. We still got quite a bit to go, maybe. Having decided the existence of the First Amendment right, we now turn to whether the officers are entitled to qualified immunity. We conclude they are. Government actors are entitled to qualified immunity unless they violated a constitutional right so clearly established that every reasonable official would have understood that what he is doing violates that right. Referencing to Zagola v. Borough of Mosick, let's see, 2016, and then Rachel v. Howard's 2012. In other words, existing precedent must have placed the statutory or constitutional question beyond debate. We do not need Supreme Court precedent or binding Third Circuit precedent to guide us if there is a robust consensus of cases or persuasive authority in the Court of Appeals. Making reference to LRV District of Philadelphia, 2016. Alteration of citations omitted. District court decisions, though not binding, also play a role in qualified immunity analysis. Doe v. Delhi, Third Circuit, 2001. To determine whether the right is clearly established, we look at the state of the law when the retaliation occurred, here in 2012. To conclude, the clearly established inquiry reframe the right in light of the specific context of the case, not as a broad and general proposition. Citation omitted. As needed by a specific enough to be put to reasonable official on notice of it. Some more references. At issue, here is the plaintiff's ability to record the police carrying out official duties in public. We have never held that such a right exists, only that it might. Reference to the Gills v. Davis. Videotaping or photographing the police in the performance of their duties on public property may be a protected activity. In 2010, we held that there is no clearly established right for the public to do so, at least within the context of a police traffic stop. We find these cases insufficiently analogous to the fact that there is a case, but have to put Officer Rogers on notice of a clearly established right to videotape police officers during a traffic stop. Only a few years later, in 2013, in a non-presidential precedential opinion, we held even if distinction between traffic stops and public sidewalks confrontations is meaningful, our case law does not clearly establish a right to videotape police officers performing their duties. In 2009, reference to another case, so to resolve whether the right has become clearly established after the discussion, we must decide whether the robust consensus has established that puts the existence of the First Amendment right beyond debate. Plaintiffs contend the absence of circuit precedent does not end the inquiry, as after the events of Kelly and True Blue, the Philadelphia Police Department adopted official policies recognizing First Amendment rights of citizens to record police in public. As plausible as it may be on the surface, it does not win the argument. With one breath, the plaintiffs assert that these policies clearly establish there is a right, but for the purpose of municipality liability, an issue we reminded, they vigorously argue that the policies were utterly ineffective in conveying to the officers that the right clearly existed, and the plaintiffs have compiled evidence indicating this was so. For example, they pointed out that Captain Francis Healy, the policy advisor to the police commissioner, testified that notwithstanding the adoption of the department's policies, the officers didn't understand that there was a constitutional right to record. As to discussion of other appellate courts revealing that the qualified immunity analysis, defendants and the district court argue that decisions are distinguishable because they involve expressive intent or intent to distribute. See reference to Alvarez. The ASLU intends to publish these recordings online, and though other forms of electronic media, make a reference to Glick, the plaintiff expressed concerns police were using excessive force, arresting a young man in a public park, and began recording the arrest on his cell phone. And the police then arrested the plaintiff. Notably, the plaintiff, in 40th reference in the Ninth Circuit, claimed he was recording a public protest for a few local news stations. See also DOJ Amicus Brief 22. In those cases, plaintiffs' objectives or opinions to disseminate were apparent from context. In this respect, Field's case in particular is one of first impression. Indeed, the Fifth Circuit just this year recognized that these other appellate decisions did not clearly establish the constitutional right to record. See Turner. Okay, I'm not sure who's trying to get a hold of me right now. But, continuing on, all contain some element of expressive conduct and criticisms of police officers and patiently distinguishable from Fields and Garcia activities. Whether the defendant or the district court correctly distinguish these cases, we cannot say that the state of the law at the time of our cases, 2012, 2013, gave fair warning so that every reasonable officer knew that absent of some sort of expressive intent, recording public police activities was constitutionally protected. Accordingly, the officers are entitled to qualified immunity. So that is quite interesting. But then again, the general incidences was like 2012 here, and the other one was like 2015. And so we were still establishing the newer cases, which just came out this year. Continuing on, municipality liability, which I suspect they will definitely be liable. We're getting near the end of this. Uh, Lots of reading. Because the First Amendment ruling, the district court did not reach whether the city could be held liable for its officers' conduct. See generally Manuel v. Department of Services. While the city contended that there is no genuine issue of material fact, it cannot be held liable as a matter of law. It cannot be held liable as a matter of law. We followed the usual practices of according to our district colleague the initial opportunity to resolve these contentions. We ask much more of our police. They can be our shelter from the storm, yet officers are public officials carrying out public functions, and the First Amendment requires them to bear bystanders recording their actions. This is vital to promote their access to the access that fosters free discussion of government actions, especially when those discussions benefits not only the citizens but officers themselves. We thus reverse or remand the further proceedings. Let's see here. And then we have some opinions. Concurring the part of dissenting in part. Okay, so this is Judge Nagar J. I think I pronounced that right. I agree with the majority that the cause must be remanded because I conclude that the First Amendment right at issue is and was clearly established. I dissent. The question of whether constitutional right is clearly established has to be considered in real-world context. This is why our analysis is conduct from the perspective of the reasonable official. In reference to LR v. Sanctions of 2016, such an approach protects public officials, particularly our police officers in the field, from unnecessary uncertainty about the precise boundary and particular constitutional right when situations arise that have not yet been considered by the courts. Nonetheless, we must apply the reasonable official analysis consistently, recognizing that there is instances, rare though they may be, when any reasonable official in circumstances would know the boundaries of constitutional right well before we have ruled on it. I'm confident that this is one of those cases because of the unique combination of number of factors. First, as the majority notes, every circuit court of appeals that has considered the issue ruled that there is a First Amendment right to record police activities. Four of these discussions were published before the conduct of issue here, and two of them occurred after our decision in Kelly v. Burrow of 2010, in which we posted that the right was not clearly established at the time. Several case law references. I am convinced that such a robust consensus alone sufficiently grounds a ruling that the right is clearly established. However, our record goes far beyond that. The police department's official policies explicitly recognize the First Amendment right well before the instances under review here took place. Captain Frank Haley of the Department of Research and Planning Unit stated that in 2011, officers did not understand the police were allowed to be taped in public. Because there was some confusion on the street, he testified that there was a definite need for the policy. He said the department wanted to be on the forefront rather than on the back end of educating its officers on the issue, prompting Police Commissioner Charles Ramsey to request that the policy be written requiring police officers to allow citizens to record the police. The policy was intended to get clarification out on the streets so that the officers knew that what their duties were. It is issued a memorandum in September 2011 stating that police should reasonably expect to be photographed, videotaped, and or audibly recorded by members of the general public. Commissioner's Memorandum 11-01, issued on September 23, 2011, made it clear that all Philadelphia police officers that they shall not obstruct or prevent this conduct, and under no circumstances were permitted to disable or damage devices being used. In the year that followed the publication of the memorandum, Internal Affairs received 8 complaints by citizens of retaliation by police for recording police performances and their duties. Additionally, U.S. Department of Justice recommended that in May of 2012 that all police departments affirmatively set forth the First Amendment right to record police activity. As a result, the Commissioner directed Captain Haley and his unit to revise the memorandum to incorporate Department of Justice recommendations. The revised document was issued as a Department of Directive 145 on November 9, 2012. Like a memorandum, a directive is also official department policy, but it covers a topic in greater depth. Boy, I'm really liking this judge's argument about why he dissents with the ruling that of the immunity and the non-liability of the municipality with their policies and all that stuff. Quite interesting. Directive 145 plainly requires officers to allow citizens to make recordings of police activity. The directives uses verbatim the language Department of Justice recommended, stating that it proposes was to protect the constitutional rights of individuals to record police officers engaged in public discharge of their duties. It is said further that the observing, gathering, and disseminating of information is a form of free speech. Police officers were prohibited from blocking, obstructing, or otherwise hindering recordings made by persons unless the person making such recording engages in action that jeopardizes the safety of the officer, any suspects, or other individuals in the immediate vicinity, violate the law, incite others to violate, or actually obstruct any officer from performing any official duty. As it was published, the department mandate that Sergeant read it at every roll call, department-wide. Each police officer also received a copy of the directive and was required to sign that they received it. Although the directives declared the First Amendment right well ahead of the court, the Philadelphia Police Department Commissioner had a desire to get out ahead of what presently viewed as an inevitable ruling. With all of this, it is indisputable that all officers in the Philadelphia Police Department were put on actual notice that they were required to uphold the First Amendment right to make recordings of police activity. From a practical perspective, the police officers had no ground to claim ambiguity about the boundaries of citizens' constitutional rights here. Mindful of the established trend among the circuit courts of appeals, this combined with the clear guidance from the Commissioner sufficiently grounds a conclusion that right to record official public police activity was clearly established and beyond debate. However, this too ignores other piece of context of the case that should be considered as part of reasonable official inquiry. The majority of the cities in 2011 article, Seth F. Kramer, okay, this must be the professor that they're referring to at the early part of the discussion, in which notes, given ambiguity of personal electronic devices with cameras, we live, relate, work, and decide in a world where image capturing from life is routine. Captured images are part of an ongoing discourse, both public and private. Capture of images has become an adjunct to memory. Probably mispronounced that word. I'll practice on my English speaking later. And acceptable memorandum connections and correspondence. If we are able to assess the issue from reasonable officer's perspective, we cannot artificially remove him or her from this widespread societal phenomenon. Indeed, it is not unreasonable to speculate that most, if not all, of the police officers themselves possess such a personal electronic device at a time that incidents underlying these cases took place. A reasonable police officer would have understood firsthand the significance of the proliferation of personal electronic devices that have integrated image capture into our daily lives, making it a routine aspect of the way in which people record and communicate events. Apart from any court ruling or official directive, the officer's own lived experience with personal electronic devices, both from the perspective of being one who is recording and the one who is being recorded, makes it unreasonable to assume that the police officers were oblivious to the First Amendment implications of any attempt by them to curtail such recordings. As I noted, I concur with the majority analysis and conclusion of the recording and the existence of the First Amendment right to record, and agree with the case against City of Philadelphia should be remanded to further proceedings. However, in light of the social, cultural, and legal context in which this case arose, I am convinced that in unique circumstances, no reasonable officer could have denied at the time of the incidents underlying these cases that the efforts to prevent people from recording and their activities infringed on the rights guaranteed by the First Amendment. For the reasons I dissent from the majority conclusion that the police officers are immune to the suit from the suit. And that rounds that up. So we have this one judge who actually says that these officers should not be immune to this. Holy cow, that was quite the read. Took me, what, a good 45, maybe 50 minutes to read through all of this. But there is some really good legal arguments in here that can be held, especially from the one judge's opinion. And keep in mind, a judge's opinion may not establish case law, but the arguments can be used to establish further case law and used in other court arguments too. But this is quite the good ruling. And what was this Brown v. one? Let's see here. Landmark case, Supreme Court that struck down banning the sale of certain violent... Oh, that's a video game case. Oh, I'm going to have to read that one. I'm going to have to bookmark that for a little bit later. So, for those of you who've been here for a majority of the time and all that stuff, what did you think? Let's see here. Sorry I missed the stream last night, PNP. Oh, that's right. PNP did a stream last night. I sort of saw that when I was getting ready to set up here. More comments all over the place. But definitely quite the interesting thing we have going on here. So, do you guys enjoy the reading of the case law that we have going on here? Oops, dang it. Bring up the wrong thing here. Let's see. Of course, Joshua. No, Joshua. Caught stomach bug and was down for the count. Oh, that sucks, Josh. I've had my share of flu bugs and all that stuff. Hope you get better. Yeah, I'm getting a little bit better, even though I'm tired as hell right now, so... Not long after this, I'm going to probably crash out. I just got to do a few quick setups and while this is processing and make sure it goes public when it gets done. And see about what happens with monetization, because it seems to love to demonetize case law readings. Garcia, Jurassic. Okay, so I'm supposed to say that Jurassic, I take it. So sorry if I'm screwing up pronunciations, but how should I put it? English was never my best language. Yeah, I'm actually quite surprised about the police department's rulings of trying to get ahead of the ball game there. In which case, in my opinion, should have put in place that they deserve to lose qualified immunity. Oh, that sucks about the Allentown Police Department. Well, you got more case law to back you up. Filming cops, why would they think it was? Reading case law aloud makes it interesting. Well, I try to give my input as much as possible. This information definitely helps out those that are trying to get out there and do the filming, or just those trying to exercise their rights. My wife, Sizzle Pie, and I say hi, Bunny. Hey. Yeah, Sizzle Pie. I'll probably need to stop by there and pick up some pizza at some point. maybe live stream from there. And what was it? I was trying to think here. Yeah, I think before the end of the year, I'm gonna try to do a reading of Turner v. Driver and ACLU v. Alvarez, because I think we need to have that information on hand for, how should I put it, pushing the post office issue. And maybe the courthouse issues further or something like that. I don't know on that part, but definitely the post office's issue needs to be addressed at some point. Though there was a really good video the other day where uh, someone went filming. I can't remember who it was off the top of my head, and the officer told the post office lady that she could be filmed, and the look on her face when the officer told her that she could be filmed was just hilarious. Cops say don't film this and that, and then ask for footage if something goes on. Yeah, it's quite hilarious how if there's a big, huge incident, they will go nuts about, oh, we need the general public's film video footage and stuff like that. But when it's gonna make them look bad, it's like, don't film this, don't film this. Well, I might as well go ahead and call it into the stream here, and I think I'll go ahead and end it off. I've already filmed DMVs a couple of times. If you check my channel history. Yeah, and there's a few other people that have filmed DMVs. Let's see here. What shall we go for an outstream music here with Techno Axe? Techno Axe, Strumming by the Fire was what we were listening to here for outgoing music. And what the heck just happened here? Oh, that's right. I must have hit the button wrong. Oh well. We'll just go with an outro music of Strumming by the Fire. Anyway, have a good night. Well, have a good day. I need to get some sleep because I have some business to tend to for the day. Well, a little bit later today, and I at least need 1 or 2 hours of sleep before I do that.